Hi, and welcome to the 9th episode of my vlog, Personal Injury Lawyer Tips. My name is Leroy Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis Inc. book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, and the founder and owner of my law firm, Rudder Law Group. In this vlog, I'll be discussing the unique circumstances where you, the plaintiff, are able to prove, on a balance of probabilities, 50% plus 1, that the injuries you sustained was a result of an accident caused by the negligence of at least one of two defendants, but you are unable to prove which one's negligence ultimately caused the accident. This fact pattern can potentially leave a court in a legal quandary, as it would be left with a great degree of uncertainty over what to do in the interest of justice. An argument can be made that it would be unjust for a court to impose liability on one of two defendants who you have failed to prove, on a balance of probabilities, to have caused your injuries and impairments that you are suing in tort for compensatory damages. However, a strong policy argument can also be made that it would be equally unjust to not give compensatory damages to you, the innocent plaintiff, who suffered a severe or catastrophic injuries and impairments. In such a factual scenario, where a court has to make a difficult ruling between two legitimate alternatives, which are prima facie equally undesirable due to the consequences to one innocent party, the court must ensure that its decision is coherently in accordance with principles established from jurisprudence in order to serve the ends of justice. The court has to decide whether or not the injustice of imposing liability on a defendant who did breach a duty of care owed to the plaintiff, but whose negligence didn't directly cause the accident, is sufficiently outweighed by the injustice of denying redress to an innocent victim seeking compensatory damages in restitution. The Supreme Court of Canada had to deal with this legal quandary in a 1951 case entitled Cook and Lewis. In this case, the plaintiff was shot in the face by a bird shot while hunting. The two defendants, together with a third hunter, were hunting for grows, and admitted at trial to discharging their guns in the vicinity of the plaintiff, almost at the same time, but not at the same grows. The jury found that either the first or second defendant hunter had been the cause of the injury sustained by the plaintiff, but the jury declared that the plaintiff had not satisfied them which of the two it was, which created a problem of proof. The jury also found that the injuries were not caused by the negligence of either. Since the jury obviously answered the questions in an unclear and perverse manner, the action was dismissed by the trial judge. However, the Court of Appeal for British Columbia ordered a new trial, and then the Supreme Court of Canada agreed. I'd like to now focus on the third question that was put to the jury by the Honorable Justice Wood, which was, quote, "If the plaintiff was shot by one of the defendants, are you able to decide by which one?" End quote. The jury answered no, because they were unable to find which of the two defendants fired the shot which did the damage to the plaintiff. The Supreme Court of Canada referenced the general rule that was approved in the case entitled Moxley and the Canada Atlantic Railway Company as follows, quote, "Thus, in practice, when it is certain that one of the two individuals committed the offense charged, but it is uncertain whether the one or the other was a guilty agent, neither of them can be convicted." End quote. The Supreme Court of Canada noted this rule was also applicable to civil actions, so that if at the end of a civil trial, you, the plaintiff, have proved that you are negligently injured by either the first defendant or the second defendant, but you are unable to establish on a balance of probabilities, 50% plus 1, which of the two defendants caused the injury, then your action must fail against both defendants unless there are special circumstances which render the rule inapplicable. The reason is because historically, our jurisprudence in Canada has always required a strict proof of causation, where you, the plaintiff, claiming negligence on the part of the other party, typically the defendant, has to show that, on a balance of probabilities, 50% plus 1, the defendant's conduct or behavior caused the injury that you sustained in order to impose liability on the defendant to pay your compensatory damages. The plaintiff in the Cook and Lewis case, however, argued that such special circumstances existed to depart from the aforementioned general rule. The plaintiff argued that the two defendants were joint tortfeasors who engaged in a joint enterprise under such circumstances that they were liable for the acts of the other, which was evidenced by the fact they were hunting together and agreed to divide the bag evenly. However, the Supreme Court of Canada noted it was, quote, unable to find any authority for the proposition that the mere fact that a party of persons are hunting together and have agreed to divide the bag renders each liable for the torturous acts of all the others, end quote. The plaintiff also argued that the cause of action against the two defendants should be the same, because again, they were joint tortfeasors, which would mean that they fall into a certain class of persons, such as the following examples. The agent, who commits a tort within the scope of his employment for his principal and the principal. The servant, who commits a tort in the course of his employment and his master. Two persons who agree on common action in the course of and to further which one of them commits a tort. These are examples of judicially accepted classes of joint tortfeasors, where one tort committed by one of them is committed on behalf of or in concert with another. So this begged the question, were the tort defendants in the Cook and Lewis case deemed to be joint tortfeasors during their hunting expedition? The Supreme Court of Canada pointed out the difficulty of applying the legal definition of joint tortfeasors to the defendants in the Cook and Lewis case as follows, quote, to do so would bring about the result that every member of a party going out together with a lawful common object, social or sporting, which could be carried out without negligence, would be vicariously liable for the negligence of any member of the party. So far as I have been able to ascertain, such a liability has not been held in any reported case to exist at common law. There was, I think, no evidence in the case at bar in which it could be found that the relationship of principal and agent, or of master and servant, or of partners existed between Aikenhead and Cook. They were engaged in a lawful pursuit. Neither had any reason to anticipate that the other would act negligently. Neither had, in fact, either the right or the opportunity to control the other. Neither appears to have assisted or encouraged the other to commit a breach of any duty owed to the plaintiff, end quote. Therefore, the Supreme Court of Canada rejected the notion that the two defendants in the Cook and Lewis case fell within the legal definition of joint tortfeasors. The plaintiff also argued that principles stated in the judgment of an American case entitled Summers and Tice should be followed. The plaintiff argued that the jury might have found the defendants liable if, in their view of the direct and circumstantial evidence adduced, they believed both defendants fired in the direction of the plaintiff, and under such circumstances that their respective conduct constituted a breach of a duty that was owed to the plaintiff. The Supreme Court of Canada wasn't able to find any Canadian or English cases that considered this particular proposition of the law, but still considered the judgment, which read as follows, quote, when we consider the relative position of the parties and the results that would flow if the plaintiff was required to pin the injury on one of the defendants only, a requirement that the burden of proof on that subject be shifted to the defendants becomes manifest. They are both wrongdoers, both negligent toward the plaintiff. They brought about a situation where the negligence of one of them injured the plaintiff, hence it should rest with them each to absolve himself if he can. The injured party has been placed by defendants in the unfair position of pointing to which defendant caused the harm. If one can escape, the other may also, and the plaintiff is remediless. Ordinarily, defendants are in a far better position to offer evidence to determine which one caused the injury. This reasoning has recently found favor in this court, end quote. Therefore, the judgment in the Summers and Tice case, if followed, provides justification for a court to decide that the injustice of imposing liability on a defendant who did breach a duty of care owed to the plaintiff but whose negligence didn't directly cause the accident is sufficiently outweighed by the injustice of denying redress to an innocent victim seeking compensatory damages and restitution. However, the Supreme Court of Canada did not think it was necessary to decide whether the aforementioned proposition in law laid out in the Summers and Tice case should be accepted as stating the law of British Columbia, but noted that if under the circumstances of the Cook and Lewis case, the jury, having decided that the plaintiff was shot by either the first or second defendant, found themselves unable to decide which of the two shots hit the plaintiff, because in their opinion both defendants shot negligently in his direction, then both defendants should have been found liable. The notion of imposing liability on a defendant, where it can be proven that his or her negligence caused the accident, smells of the legal doctrine res ipsa loquitur. The thing speaks for itself, which has plagued our courts for over a century until it was finally laid to rest by the Supreme Court of Canada in 1998. If you want to learn more about the legal doctrine res ipsa loquitur, then please watch episode number 7 of my vlog entitled The Modern Application of Res ipsa loquitur. The Supreme Court of Canada in the Lewis and Cook case seemed to embrace the spirit of the judgment in the Summers and Tice case, as well as the idea of an imposition of a provisional or tactical burden to the defendant, not a shift of the burden of proof. In situations where the direct or circumstantial evidence adduced by you, the plaintiff, results in an inference being drawn that's adverse to the defendant, which requires the defendant to adduce evidence to the contrary, or run the risk of an adverse inference against him or her. This notion of an imposition of a provincial or tactical burden was articulated by the Honorable Justice Sapinka in the Supreme Court of Canada case entitled Snell and Farrell. In the Lewis and Cook case, the Honorable Justice Rand eloquently expressed the rational justification for a shift in the onus of proof, which is similar to an imposition of a provisional or tactical burden to the defendant, when he stated the following, quote, "What, then, the culpable actor has done by his initial negligent act is, first, to have set in motion a dangerous force which embraces the injured person within the scope of its probable mischief. Next, in conjunction with circumstances which he must be held to contemplate, to have made more difficult, if not impossible, the means of proving the possible damaging results of his own act, or the similar results of the act of another. He's violated not only the victim's substantive right to security, but he has also culpably impaired the latter's remedial right of establishing liability. By confusing his act with environmental conditions, he has, in effect, destroyed the victim's power of proof. The legal consequence of that is, I should say, that the onus is then shifted to the wrongdoer to exculpate himself. It becomes, in fact, a question of proof between him and the other, an innocent member of the alternatives, the burden of which he must bear. The onus attaches to the culpability, and if both acts bear that taint, the onus, or prima facie transmission of responsibility, attaches to both, and the question of the sole responsibility of one is a matter between them, end quote. Therefore, in factual scenarios like in the Lewis and Cook case, where two defendants are found to be negligent in their conduct and behavior, but science cannot assist with accurately determining which defendant's negligence precisely caused the damage to the plaintiff, the Honorable Justice Rand offers another legitimate argument to rule in favor of the victim, the plaintiff, even though only one of the defendants caused the accident, by reframing the argument around the factor of culpability in determining legal responsibility for damage done to the plaintiff, and stating that the onus should attach to culpability as opposed to causation. The justification for the shift in onus is essentially that not only did the negligence of both defendants, even though only one of them caused the damage, breach the duty of care they owed to the plaintiff by setting in motion a dangerous force that embraced the plaintiff within its scope of adverse probable consequences. They have also made it extremely difficult, if not impossible, for proving that the damages sustained by the plaintiff were from their negligent conduct or behavior. As such, again, the defendants not only violated the plaintiff's substantive right to security, but they also culpably impaired the plaintiff's remedial right of establishing liability, that's required to successfully obtain just restitution via compensatory damages. So in conclusion, in a factual scenario such as in the Lewis and Cook case, a strong argument can be made that the evidential difficulty from the impossibility of identifying which of the two negligent defendants in your case ultimately caused you damage should come back upon the two negligent defendants and not you, the blameless, innocent plaintiff. The unfortunate consequence that one of the two defendants will be found to be liable for an injury to you, the plaintiff, that he or she did not in fact inflict, is outweighed by the less attractive alternative, which is that you, the innocent plaintiff, who has had both your substantive right to security and right to establishing liability violated by both of the defendant's negligence, would receive no compensatory damages and just restitution, even though at least one of the negligent defendants injured you. Therefore, embracing a more flexible, robust, and pragmatic approach to causation, as opposed to a stringent application of the traditional approach to causation, is necessary in these exceptional circumstances, such as the factual scenario in the Cook and Lewis case, where the unattractiveness of holding a defendant responsible for damages sustained by the plaintiff that his or her negligent actions didn't directly cause is outweighed by the prospect of leaving the blameless victim, you, the plaintiff, without redress or just restitution. If you want to learn more about the difference between the traditional approach to causation and the robust and pragmatic approach to causation, stay tuned for episode number 10 of my next personal injury lawyer tips vlog entitled, "What is the difference between the traditional approach to causation and the robust and pragmatic approach to causation?" I hope you found this information valuable. If you want more information, then please read my blog of the same name called "How Do You Determine Liability When at Least One of Two Negligent Defendants Caused the Accident, but You Can't Prove Which One." In my blog, I take a deep dive into the unique circumstances where a plaintiff is able to prove, on a balance of probabilities, 50% plus 1, that the injuries he or she sustained was a result of an accident caused by the negligence of at least one of two defendants, but is unable to prove which one's negligence ultimately caused the accident. I also provide links to other blogs such as "What is the difference between the traditional approach to causation and the robust and pragmatic approach to causation," which provide additional information you find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at rudderlawgroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs of valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you. And I'll see you soon in episode 10 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.